and we're starting with a formal part of the meeting. So welcome once again in this semester to another Belgrade Legal Theory Group meeting. Today's meeting will be devoted to the philosophy of evidence or philosophy of evidence law, and with us is a great friend and colleague and collaborator, and I'm really glad to see him here, at least online. Hopefully we'll see each other soon in Milan or in Belgrade live. But this is definitely the next best thing. No better person to speak about evidence law, which is or philosophy of evidence law, which is unfortunately in Belgrade a bit was and is put to the side, and I'm certainly hoping that this presentation will give at least the students and of course all the others an opportunity to think about the philosophy of evidence law and to consider starting their work in the philosophy of evidence law. Giovanni did a lot of work in epistemology connected to evidence law, did a lot of work in evidence law, and he'll tell you all about it. Last year, he published a very important thing and contentful volume regarding the philosophy of evidence law. Without further ado, I give the floor to Giovanni. So the floor is yours.
Thanks, Bojan, for your kind invitation and these words that honor me, and I'm happy to give this talk. I've prepared some slides. Shall I do something about them right now? Do you have uploaded them already? Please, Bojan, let me know what.
Can you? Okay, wait. Can you share them?
I'll try. On
okay.
DVD. Here they. Can you see them?
Yes, now we can see them. You can make it full screen, and I think it will work perfectly.
Okay, so it will be like this. There you go. All right. Maybe you can see also my face somewhere. I'm not sure, but I hope so. Okay. And I'll try to be brief. There's a lot of stuff in the slides. I've prepared a lot of material in a way, because the idea was to give you an overview of different topics in the field of the philosophy of evidence law. So there's a lot of stuff. I will say something on several points, and if I am unclear, please stop me and ask clarification questions, or if you have critical considerations, please interrupt me and make them. There will be some room at the end of the presentation for additional questions or considerations. So yeah, we have the occasion to discuss about these topics. And I'll be brief about some of them, and we'll stop longer on some others. Okay? So this is the presentation outline. I will say something on some major topics in the philosophy of evidence law. So there will be a list of topics that are particularly important. Then a few words on evidential reasoning, since the reasoning on evidence is one of the key topics in the field. Then something about evidence assessment and decision after the evidence is assessed. And when the topic is the decision after the assessment of the evidence, the crucial point is the understanding of the applicable standard of proof. And then the rest of the presentation will be about standards of proof that can be understood differently in a qualitative way or in a quantitative way. I will say some words on these two ways of understanding standards of proof. And I will mention also some comparative work on this topic, the topic of standards of proof, which is one of the topics at the frontier of legal studies on evidence law and philosophical studies on evidence law. I've seen that some of the people who are attending are people are involved in the field, so they will certainly understand why I've just said this. Okay. Now, some topics in the field of the philosophy of evidence law. First of all, one traditional topic is an understanding of the nature and function of juridical evidence. So, what's juridical evidence? That's the question. And what are the functions of juridical evidence? Okay, these are very traditional topics. I will just say a couple of things on this later on. That's about juridical evidence, okay? Next point, the purposes of evidence law, which is the law about juridical evidence. So the law about the admission, the evaluation, etc. of juridical evidence. So the body of law that has to do with juridical evidence. What are the purposes of this law? That includes so-called exclusionary rules. I will say a few things about these rules too. Okay. Another topic, as I mentioned, is the nature of evidential reasoning. What are the forms, or what are the ways in which evidential reasoning is performed in the courtroom and in legal context, more generally speaking. Okay, if you had the chance of taking a look at the papers I sent to Bojan, and were the papers that were circulated, I think, you've probably seen that my 2019 paper is about this topic, the variety of evidential reasoning that is performed in legal context. Deductive forms, inductive forms, abductive forms, inference to the best explanation, okay? And then the other paper that I sent you is about standards of proof, and this is the topic that I want to go deeper into today. When it comes to standards of proof, there is a controversy in the actual debate over the probabilist understanding of standard of proof. So it's the controversy over probabilism. I have put it this way. Okay, so this is just a list of some major topics in the field. Okay, so now let me say something more about some of them. Of course, I won't have the time to discuss all of them in detail. Details. The nature and function of juridical evidence. Okay, that was the first topic I mentioned. What's juridical evidence, and what are the functions of juridical evidence? This is a very standard, if you want, account that I'm presenting. Evidence enables fact finders to reach accurate verdicts on disputed facts. So by fact finders, we mean judges and jurors. Okay, as you know, some systems have juries, some other systems don't, or have them only to some limited extent. So let's call them fact finders. Let's call fact finders, both judges and jurors are fact finders. So juridical evidence enables them to reach accurate verdicts, or true verdicts, if you want, on disputed facts. Of course, facts that are not disputed do not need any presentation of evidence about them. Okay, so if some fact is undisputed, there's no need to collect evidence about it. But when facts are disputed in a legal context, in a judicial context in particular, you need evidence to decide upon it. Okay, and evidence enables fact finders to reach accurate or true verdicts about those facts. But remember that evidence, being something like documents, photographs, testimonies, material objects, etc., whatever can help fact finders to reach an accurate verdict, per se, evidence per se does not yield verdicts. I mean, evidence is just what helps fact finders to make a verdict, okay? So there are basically three requirements on evidence that I list here. First of all, you must construct some argument out of the evidence, okay? It is not sufficient to present a material object or a document to the fact finders and then wait what happens. I mean, you as a party in a trial, you have to construct an argument based on the evidence, okay? An evidence, some evidence is presented, an argument is constructed on the evidence, and then some conclusion can be reached, okay? So in a more technical way, I put it like this: evidence must be inferentialized, which is maybe a weird word. It means that you must construct some inferences or some arguments out of the evidence to persuade the fact finders that the facts have been in a certain way rather than another, okay? Next, once you have the argument based on the evidence, you need an assessment of the argument. You need to determine, to say it technically, its probative value. What's the value of the evidence, and what's the value of, better, to put it better, of the argument that is constructed out of the evidence? That's a crucial passage in order to make a decision. And finally, the fact finders, judges, or jurors need to consider whether the evidence, as it has been inferentialized and assessed, meets the relevant standard of proof. That is, if it is sufficient for a certain decision on the case, on the facts in particular, okay? So remember, evidence is necessary, but it must be transformed, or, well, it must be processed in this way: inferentialized, assessed, and consider in the perspective of the applicable standard of proof. Remember, this is a terminological note, that in the Anglo-American vocabulary, there is a difference between evidence and proof. Some languages do not have this terminological difference. Of course, we have different concepts, but in Italian, for instance, we have the word prova. In Spanish, prueba, that means both things. In English, they have two words, evidence and proof. Evidence is anything that can be used to prove a fact, as I said: documents, pictures, material objects, testimonies, etc. Okay, that's evidence. We call proof in English the positive outcome of the process. When the evidence presented, inferentialized, assessed, is sufficient with respect to a certain standard of proof, the applicable one, we say that, oh, now we have the proof of the fact, okay? But the proof, the so-called proof, is the outcome of the process, and a positive outcome in particular, based on the evidence that is presented, blah, 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 okay? That's a terminological point. I hope it's clear now. Now, as I told you, one thing is evidence, another thing is evidence law. The evidence, the legal rules or legal principles concerning evidence. Okay, what's the need of that? Well, first of all, evidence law can help fact finders make accurate verdicts. Okay, so evidence law is an aid to fact finders in some respects. But that's just one of the purposes of evidence law. It's not the only one. It's not just for the sake of truth. Evidence law protects or promotes other values as well. For instance, evidence law, or some rules of evidence law, have the purpose of guaranteeing the fairness of legal proceedings. Some rules protect other values too, for instance, fundamental values in particular. The so-called exclusionary rules have the purpose of excluding illegally obtained evidence. Evidence that is obtained illegally by the police, for instance, cannot be used in a trial. If there is an exclusionary rule that says this, you cannot use it as a fact finder some kind of illegally obtained evidence, okay? And additionally, evidence law is also the purpose of promoting the efficiency of proceeding. No waste of time, no waste of resources. Speedy trials are welcome, of course, because trials that are too long result in sort of injustice. So we need some evidence law for these different purposes. Remember this. It's an interesting point because some people just think about evidence and evidential reasoning for the purpose of true verdicts. Well, that's only a part of the story. We need fairness, we need the protection of fundamental values, and we need efficiency also. And these values can be in tension with one another, of course. Excluding illegally obtained evidence can be a cost for the purpose of a true verdict, but it's a cost that in constitutional orders we are ready to pay because we do not want, for instance, the police to obtain illegally the evidence that is needed to prove a certain fact. Okay, so there's a variety of purposes that evidence law has, and if you are interested in this, I mean, there's a lot of discussion about this. There are interesting cases that are discussed, and we can discuss this in more detail later on if you wish. Now, evidential reasoning. What time is it? Okay, evidential reasoning is one of the key topics in the field of the philosophy of evidence law. What is the kind of reasoning that is performed about evidence, starting from theoretical evidence? Here's a simple case. That's very simple, just to give you an idea of the very basic patterns of reasoning. Okay, so consider this very simple case. A car was stolen. Okay, a certain guy called Otto is found to possess the stolen car. So the police find that Otto possesses the car that was stolen. Okay, well, it's pretty natural to formulate what? A hypothesis concerning what happened. And since this will be a criminal case, let's say that the prosecutor makes a charge against Otto. Based on what? Based on the evidence. And in this case, the evidence is that Otto possesses the stolen car. So, given that he possesses the stolen car, this is the evidence, the prosecutor makes the hypothesis that Otto stole the car. He is responsible for the theft. Okay? That's a hypothesis that can be formulated on the basis of the evidence. And once the prosecutor advances this hypothesis and supposedly Otto defends himself, claiming, no, I just got the car from a friend of mine that gave it to me, I didn't know it was a stolen one, etc. Okay, so let's imagine that there is a dispute. Otto denies being the thief, and the prosecutor asserts that. Okay. When the evidence is collected, when the arguments are constructed and evaluated, then the fact finder, judge or juror, has to decide whether the claim of the prosecutor in this case is justified. Okay, this is a very simple case. And how can the fact finders understand whether the claim is justified? Well, they need to consider the evidence, the arguments, how the evidence was assessed, and most of all, they need to consider the standard of proof, the applicable standard of proof. Does the evidence as presented, inferentialized, and assessed satisfy the relevant standard of proof? If yes, it means that it is sufficient to a verdict against Otto in this case. If it doesn't meet the standard of proof, well, the fact is not proven. So this person, Otto, shouldn't be convicted, should be acquitted of that charge. Okay, so this is a very simple case, and in a sort of more schematical representation of it, you have as a starting point the evidence. Otto possesses the stolen car, let's call it E, and you have at the end the hypothesis that Otto stole the car, which is in a way justified by a sort of generalization that can be used as a premise, as a major premise of the argument. If X committed the theft, then X possessed the stolen goods. That's a generalization that we can generate from common sense, from the experience of how things go in the world, but it doesn't guarantee the truth of the conclusion, right? That's just a hypothetical conclusion. We can make the hypothesis that Otto stole the car. We cannot be sure of that, okay? And evidential reasoning is usually hypothetical. Technically speaking, it's a matter of abduction, or, if you wish, of inference to the best explanation. These are more technical phrases that I won't discuss now, but if you take a view at my paper, you will understand what I mean. The basic point is that evidential reasoning is usually, maybe I can say almost always, hypothetical. Okay, so the conclusions are hypothetical. They are not deductive conclusions. They are not certain conclusions that are certainly true. Okay. The more evidence you have, the stronger the conclusion can be. Consider this case. Otto possesses the car. That's item 1, E1, first item of evidence. Suppose that we add an item number 2, which is a DNA trace is found where the car was stolen, and the trace is compatible with Otto's DNA. And an item that we call E3 is also collected. That is the testimony of a witness who saw Otto there when the car was stolen, supposedly. Okay. So if you start from these premises and you add some generalizations, as before on possession, plus reliability of DNA evidence and reliability of that witness, you can have, again, the conclusion that Otto stole the car as a hypothesis, which is now stronger, which has more support from the evidence. Okay? So the case against Otto here is certainly stronger than before. But remember, it's not absolutely certain. H, the hypothesis, is not deductively entailed by the evidence. So you can have conclusions that are more or less strong, more or less plausible, more or less probable, right? And here comes the topic of the standards of proof, which is the other thing that I want to mention today. Standards of proof are the thresholds of the sufficiency of evidence in order to have a certain decision. Okay, I have a discussion about standards of proof now, which is premised on a caveat. Okay, the caveat is this: don't take standard of proof and criteria of evidence assessment as the same thing. They are different. First of all, you have to assess the evidence. Then you can make a decision on it based on the standard of proof. Okay, so remember that analytically speaking, assessing the evidence is one thing and deciding in light of a certain standard is another. And unfortunately, some courts, as the European Court of Human Rights, are sometimes a bit confused about this. For instance, in a famous case of some years ago, the court says that in assessing the evidence on which to base a decision, the court adopts the standard of proof beyond reasonable doubt. Well, that's not a very clear way of putting it, because the standard of proof is just the threshold. And before making a decision based on that, you have to assess the evidence with some criteria. So they're not the same thing, okay? And unfortunately, there is some confusion about this, not only in judicial opinions like this, but also in some scholarly work. So remember that analytically speaking, these are different things. But there is a functional connection. There is a functional connection, of course, because you assess the evidence as a fact finder in order to understand whether it meets the standard of proof. So there are two steps. You can visualize that as a multi-step process in which assessment comes before decision given standard of proof. Okay, I hope it's clear enough. And one of the troubles is that our legal systems are not always clear about this. However, the three major standards of proof that you find in common law countries, at least, are the following. The first is the civil standard of proof that is called the preponderance of the evidence, which says that a certain claim, the claim of the plaintiff in a civil case is proven when it is supported by the preponderance of the evidence. Okay. In a more quantitative version, the idea is expressed by the phrase "more probable than not." In civil cases, the civil standard is the idea that if the claim of the plaintiff is proven by the preponderance of the evidence, or it results to be more probable than not, given the evidence, then the standard of proof is met. And the decision makers, the fact finders, have to decide for the plaintiff, okay? In quantitative terms, it means any probability value that is greater than 0.5. For any probability value that is greater from that, the claim is proven. So if the burden of proof is on the plaintiff, as it usually is, then the plaintiff wins the case, okay? In some civil cases that are particularly serious because the stakes are particularly high or significant, the American law has a second standard of proof that is called the clear and convincing evidence standard. This is a sort of intermediate standard that is used in some cases, okay, in America, not in the UK, for instance. The UK doesn't have this. The clear and convincing evidence idea is the idea that evidence must be stronger than in usual civil cases. In some civil cases where what is at stake is particularly important, in the US, you need to meet this standard of proof in order to have the claim accepted. If you are the plaintiff, the evidence that supports your claim must be clear and convincing. What is the quantitative version of this? Some people say, well, the threshold is around 0.7. So for any probability value greater than, equal or greater than 0.7, that's fine. The claim is proven. And finally, you have the famous beyond a reasonable doubt criminal standard, which is the idea that in order to convict someone, a criminal defendant, the guilt of the defendant must be proven beyond a reasonable doubt, which is the highest of the standards, the highest of the thresholds. I mean, the one that is most difficult to meet, because you have to exclude any reasonable doubt about the defendant's innocence, okay? According to this standard of proof, the defendant, the criminal defendant, can be convicted only if guilt is proven beyond reasonable doubt. That is, you cannot have a reasonable doubt about that. I mean, and in quantitative terms, this is something like 0.9. So for any probability value equal or greater than 0.9, the defendant must be convicted, okay? That's a sort of standard account of standards of proof in the common law jurisdictions and world. What about the civil world? Just a few slides on what happens generally in the civil law countries. I'll start from Italy. In Italy, we have an interesting mixture of aspects, because in the Civil Procedure Code, we have an article about the evaluation of the evidence. Notice, remember the analytical point that I made earlier. Evidence assessment is one thing, decision according to a standard of proof is another thing. They are functionally connected because you have first evidence, assessment, then you have decision, given standard of proof. They are connected, but they are not the same thing. And in the context of Italian civil procedure, you have an article which is about evaluation of evidence, that is assessment, that must be according to the prudent assessment of the judge, but there is no indication, positive indication, explicit indication in positive law of the standard of proof, and that's a problem. We have many judicial opinions in the last years about the standard of proof in Italian civil cases, and I mean, there are different views the judges, even of the judges of the Supreme Court, the Corte di Cassazione. So it's a kind of problem in Italian civil cases. Instead, in the Criminal Procedure Code, there is an explicit indication of the standard of proof, which is the beyond a reasonable doubt standard. Because in Italy, since 2006, we have an explicit indication of that in the Criminal Procedure Code. So the legislator decided to import, so to say, in Italy, the traditional American and English standard of proof in criminal matters, which is beyond reasonable doubt, okay? So it's a sort of mixed system now, the Italian one. France is different in that the Civil Procedure Code doesn't say a lot on these matters, and instead in the Criminal Procedure Code you have the famous indication of decision according to intime conviction, which is something that has generated a lot of criticism, in particular in the Anglo-American world, where people say, well, what's intime conviction? It's just a psychological standard. That's crazy. You cannot decide just on your on your psychological conviction. So it's something that has been criticized a lot by Anglo-Americans, also by some Spanish scholars, as Jordi Ferrer. I think some criticism is a bit unfair because it's intime conviction based on the evidence. However, just to let you know, France still has this standard or evaluation of evidence criterion that is in the code since the French Revolution. It's a long story. I don't have the time now to tell you about that, but it's something that was introduced in France with the French Revolution and is still there. Intime conviction is the standard or evidence assessment criterion that is mandated by French positive law in criminal matters. Civil law countries in the Spanish-speaking context world have very frequently the idea of evidence evaluated or assessed according to the rules of sound criticism, that is las reglas de la sana crítica, which is, similar to the Italian prudente apprezzamento, in a sense. And in the Criminal Procedure Code of Spain, you have instead the idea of judges deciding after they have assessed the evidence according to their conscience, which sounds like the French intime conviction. So you see that different legal systems have different ways of dealing with these matters, okay? Similarly for other Spanish-speaking countries, with some exceptions, because Chile, for instance, uses sound criticism, la sana critica, as a way of assessing the evidence, and beyond reasonable doubt as a way of deciding, given a certain standard. Okay. I have also a slide on Germany. Where you have the idea of decision according to discretion and personal conviction of the fact finders, which is criticized by some scholars. Again, a similar idea of free conviction in the Criminal Procedure Code of Germany. So different legal systems have different ways of dealing with these matters. Now, just to conclude on this, so we'll leave some time for discussion. I want to tell you why. I want to tell you what the rationale is for having different standards of proof according to some standard account in the international literature. Okay, so as I said, there are in the Anglo-American world basically three standards of proof. Preponderance of evidence, clear and convincing evidence, and beyond reasonable doubt. And some civil law countries like Italy and Chile have imported some of them, in particular the criminal one. Now, the theoretical question and philosophical question, why have these different standards? Why have different standards instead of just one? It would be much simpler to have just one standard proof for every kind of proceedings, for every kind of trial, just one standard. Okay, why do we need to differentiate between civil cases, criminal cases, or even between normal civil cases and serious civil cases, as the Americans do? Why do we need that? The standard answer in the theory of evidence law is that what explains and justifies the different standards are the different costs of the errors made by the fact finders. The higher the error cost, the higher the standard must be. Very intuitively, in criminal law, an error against the defendant, so putting in jail someone who is innocent, has costs that are usually perceived as greater than the cost of deciding erroneously a civil lawsuit. Okay, if you give some money to the plaintiff, even if he or she didn't deserve that money, well, that's an error, that's a legal error, so we should overcome it. But as an error, it is less serious than putting in jail an innocent, right? So if that is true, and it is true that different errors have different costs, there's a need for different standards of proof, in the sense that where the costs of an error are higher, we want to have an higher standard of proof. So more evidence is required, or more convincing evidence, or more persuasive evidence is needed where the error costs are greater. Okay, this idea explains and justifies the higher civil standard in the serious cases, remember, in America, and the criminal standard, the beyond a reasonable doubt standard, which is the highest of the three standards. Okay, and what in particular justifies this high standard in criminal law is the difference between false positives and false negatives. By false positives, we mean false convictions. When someone is convicted falsely, it is because that person is innocent, right? That's a false conviction. And logically speaking, it's a false positive. We consider as guilty someone who is not, okay, materially speaking. A false negative is a case of false acquittal, when someone who is in fact guilty is acquitted. That's an error. Again, that's an error. So in principle, we want to avoid any errors as possible. But remember that false negatives are in criminal matters less serious than false positives. Acquitting the guilty is an error, but it is less serious than convicting the innocent, right? And this difference, which can be put in terms of costs, explains why we need the different standards of proof. And the highest standard is used for the purpose of minimizing false positives, okay? So the assumption on BARD, the beyond the reasonable doubt standard, is that convicting the innocent is much worse than acquitting the guilty. That's an explanation. It's a kind of standard one. The last thing that I wanted to say, we can discuss it now in the remaining time, is that the qualitative version of the standards, and in particular of the criminal one, that is the idea of proof beyond reasonable doubt, have, however, some problems. Okay, being the standard qualitatively expressed, they leave some room for discretion in the hands of fact finders. Some scholars, again, I can mention Jordi Ferrer, say that the BARD standard, but also Larry Loudon and many others, the standard, the criminal standard of beyond a reasonable doubt is in need of interpretation, because we have to tell reasonable from unreasonable doubts. We have to understand when a doubt is reasonable and when a doubt is not reasonable. So it's not easy to apply that standard. Okay, it's not something that is self-applying. I mean, you need an understanding of what a reasonable doubt is and what an unreasonable doubt is. Okay, without that, it's hard to apply the standard. So it's hard to make a decision Okay, you assess the evidence, you have the evidence there, you assess them, and then you ask yourself, oh, but now, wait a minute, maybe I have a doubt, but now I need to understand whether the doubt is reasonable or not. And how can I know that? I mean, so there's a genuine problem here. And traditionally, in common law countries, judges were supposed to give instructions to the jury, explaining to the jury how to tell reasonable from unreasonable doubt, which is anyway kind of complicated thing. In fact, there's a recent English solution to this, which consists in replacing the BART standard with the idea of certainty. Now they say in England, well, you can convict the criminal defendant only if you are certain about guilt. Okay. Now, maybe it's just it's just a way of, it's just a matter of words. I'm not sure that this is a substantial change in the law. However, it's true that the qualitative version of the standard of the criminal one has some problems. And similar problems affect the civil standard. I won't go into that now, but just to let you know. So there are problems here, but there are problems also with the quantitative version, okay? Because if you put a number there on the threshold and you say, oh, we have proof beyond a reasonable doubt when we have a probability which is equal or higher than 0.9. Well, wait a minute, why not 0.95? Why not 0.99? So you can have different quantitative thresholds. So where's the threshold precisely if you want to quantify that? And which is an even more serious problem. Can we really have numbers here? I mean, in some cases, maybe we can have numbers if we have statistical evidence and we can make calculations that are justified and appropriate. But in many other cases, I think that it's very hard to quantify the value of the evidence in probability terms that are at least intersubjectively acceptable, okay? Where do the numbers come from? So the quantitative version of the standards is problematic, especially in the criminal field. And that's the dispute and the controversy about probabilism, as I said at the very beginning. If you are a bit familiar with these matters, you certainly know that. I mean, there are in the last years many papers and essays and books about these topics, and there are some advocates of probabilism and the idea of quantifying the standards of proof on the one hand, and on the other hand, there are people who resist that idea and think that qualitative understanding of the standards is superior, even if it leaves some margin of appreciation and discretion by the fact finders. So that's the frontier, I think, of the philosophy of evidence law when it comes to standards of proof. And I will stop here. Thank you.
Well, thank you so much. I'm now hearing my voice for some reason. Yeah. We'll try to turn off something. A sec.
It happens when I work on multiple devices at once. Thank you for a wonderful presentation, Giovanni. I didn't truly, when you sent the presentation, you did a remarkable job to go through all or almost all the slides in a fantastically clear manner. So as usual, in the second part of the meeting, I open the floor for questions. There is this way of, I posted already some of the rather strict rules, or they at least sound strict in the comment section or in the chat, but you may as well unmute yourself if I can't see you now and go ahead and ask and ask whatever without even using the little hand on the side of the WebEx app.
Do you want me to stop the sharing?
Yeah,
Is
you
it
can
better
stop
for you?
sharing now. I think it's perfectly okay. Now we see one participant. So Miodrag, Professor Ivanovic has a question. You can unmute yourself, I think, Miodrag.
Thank you, Juan. Hi, Giovanni. It was really great to see you, and this presentation was really remarkable. And be sure that you will definitely be the first lecturer when we introduce the new course on evidence law at the Belgrade Law Faculty. This was as clear as possible to anyone, including those students, and I can see a couple of names of students that are on the first year of their studies. I suppose that even them, even they could understand most of the things that you've said today. So what I have to add is literally a couple of things, or maybe just to add further to your analyticity. Maybe you did it. I did not have the chance to go through the papers. I just went through the presentation. So I fully agree with your kind of analytical attempt to distinguish particularly the assessment of the evidence from the last step, which is a standard of proof, even though it's obvious, even from the wording of some of the provisions of relevant laws, that these steps are not always clearly separated. But before I turn to this, I want to go to the first step, to the step of the inferentialized, basically constructing the argument. So I would like to ask you, especially in criminal law cases, inferentializing can be also connected to what is common, particularly in the U.S. Law, as making us some sort of a narrative out of the case. So would that kind of fit your description, this narrative part? Because when we try to make some sort of the argument about the certain evidence is mostly to put it in the context of a larger case that we want to present, which is by the end of the day some sort of a narrative, because neither of the parties, even in the or even more so in complex cases, do not want to tell the true story. Basically, they are not interested in true story. They're interested in the story which will win the case. Of course, depending on the rules of the procedure and so on and so forth. More so in the American criminal law systems, but I would say that this is an overall intention in any sort of the clash, is to have two kind of different narratives from two parties. So that would be the question regarding internationalization. Is it connected to making a narrative? And as for the second and third step, for instance, I just reminded myself of the law on civil procedure, because I didn't read it probably since I was a law student. So in our case, our court has, according to its own conviction, conscientiously and carefully assess each and every proof. We do not have different words also in Serbian. So each and every proof, then assess them together, and then based on the entire procedure, reach the decision what shall count as the established facts in the case. So I would say that here assessing each and every and all together is somehow matches your distinction, if I'm following correctly. So assessing the evidence is each and every evidence is the first thing, and then based on all like cumulative effects of everything which you assessed by certain point, then you ask yourself whether the required threshold was met. And what I'm missing here, maybe you do have it in your paper, whether you have some sort of assessment standards in this second step. Do you have something like credible, reliable, more credible, less credible, like the scale of the assessment of each and every evidence? Because in the standard of proof, there is usually some sort of standard which is already provided by the legislator himself. So that is kind of, maybe I'm missing something, but I was wondering whether there is a room for this further assessment kind of marks at the second step. Thank you.
If you're okay with it, maybe Giovanni, and if you maybe noted or jotted down the questions, maybe we could have a couple of more hands raised. So
As you
if
prefer.
it's okay with you, maybe we can collect the questions, then you can answer all at once. Okay?
Okay.
Yeah.
As you
so
prefer.
the next question is from Petar Mitrovic. Petar, go ahead. We can't hear you. You look unmuted on my side, but there could be a problem with your microphone. Maybe try putting on some headphones or something like that and trying again. In the meantime, Professor Lawrence Schulz is with us. Lawrence, I can unmute you, so you can go ahead and ask the question.
Okay, do you hear me?
Perfectly.
Yes.
Okay, I'm pleased to meet you. East online, maybe the I would like to add a little question to the question. I'm used to a school in July in Florence at the European Institute. And there you always get a presentation by Scott Brewer from Harvard.
Yes.
Yeah. And he identifies abduction with inference to the best explanation. And then he adds analogy. So he has a pattern of 4 kinds of inferences.
Yeah.
My basic inclination is that you should have 3 pattern of 3, a triadic pattern, but that comes from my background. I have studied Charles Peirce and the abduction. Now, it may be just an aesthetic question to have 3 or 4 kinds. Some scholars say I have even more, some say only 2, deduction and induction. And since I couldn't read your paper as Miodrag, I would like to get an answer of that question by you.
Thanks.
Thank you, Lawrence. Alexander Mitic also raised his hand. Alexandra, go ahead.
Do you hear me?
Yes.
Yes.
Okay. I do not have a question. Actually, I have a comment, which could be of use, especially to those interested in this field. And I think that it will be interesting for everyone to think about that and to research a little bit the case of O.J. Simpson against the state.
Yeah.
The case which could which is interesting, especially from this aspect of philosophy of evidence, I think, especially so because as you probably know, and as I suppose most of the viewers know something about it. He was set free for a murder, but was later in a lawsuit obliged to pay, I don't know, a sum of about $1 million to the family. And the verdict was based on preponderance of the evidence. Something which, for example, in Serbia would never happen. Basically, it is impossible, according to our law, that someone get set free in a criminal case, and that he is later in a lawsuit obliged to pay damages to the victim. So yeah, for everyone interested in this field, I think it is worth to analyze this case as iconic case of American practice in the criminal law. Thank you very much.
Welcome.
Thank you, Alexandra. Now, if we have Petar Mitrovic, if he fixed his microphone, he would have to unmute himself. If not, we'll take unmuting as a no and as a withdrawal of the question. So, Petre, okay, we can see you again, but yeah, it's just picture, no voice. You will reserve it.
Peter, if we can't hear you, maybe you can type the question in the chat.
Petre, we can't hear you, so you can either type the question or and we'll go on with the answers to this question.
But we can let him speak like this. He's very
but
it's a very vivid scene.
It will make for great TV content on YouTube. The worst thing is he'll be forced to edit himself out because he's the one editing the videos for the Belgrade Legal Theory Group. So, okay, somebody tell Petar that we definitely can't hear him, and I'm giving the floor to Giovanni to answer the questions that we had.
Thanks a lot for your attention and the question you asked. I'll try to follow the order of them. Miodrag, two questions: the narrative one and the other on the process of assessment. Yes, there are narratives. It's a kind of usual thing. Parties elaborate narratives of what happened. It's a sort of traditional way of presenting evidence. You present evidence, and instead of constructing an argument in the strict sense out of it, you construct a narrative. You tell a story about what happened, given the evidence. Of course, not a story just out of the blue, but a story that is supported by the evidence. So, yeah, that's a way of presenting the evidence and constructing an argument in a sort of narrative fashion. It's a sort of traditional thing. I'm not going to deny that it's something that happens. It has always happened, in a sense. My purpose was however, a slightly different one. That is the purpose of seeing what the inferential structures are of narratives, okay? And the thing that I said is that almost always, if you analyze the narratives with the tools of logic and argumentation theory, you understand that they are narratives that make hypotheses on what happened. That is, if you translate the narratives into argumentative forms, you realize that the conclusions that they provide about the disputed facts are almost always hypothetical conclusions given the evidence. But of course, that is compatible with the narrative picture. In fact, there are some scholars, in particular in the Netherlands, that try to elaborate a complex model of fact-finding which takes into account these different things, that is, narratives, arguments, and also probabilities. People from the Netherlands like Henry Prakken, Floris Becks, and others have this idea. Let's put together all these different things and let's try to have a model that comprises all these ways of presenting and assessing the evidence. So yeah, that's true. Maybe I can add a point to this. Maybe if in the next years there will be a massive use of scientific evidence instead of traditional evidence, like, for instance, lay testimony, the room for narratives will be significantly reduced, because, you know, an expert is not going to tell a story in the same sense in which a lay witness does. Okay, so when scientific data are presented, it will be unclear whether it's unclear whether there are narratives in the proper sense. Okay, and the use of artificial intelligence systems and devices is going to, I think, push forward the finding process in this different direction, which is not the traditional one of narratives. But still, witnesses are generally those who tell stories. By the way, in some systems, lay witnesses are supposed to answer questions, so they are not supposed to tell a story, you know. So now we are going to listen to your story. You can talk as much as you want. I mean, no, there are questions and the witnesses must answer the questions. So it's not a story in the sense that in which we understand it in other contexts. On your second questions, yes, we can distinguish the evaluation of individual items and the evaluation of the set of them. But the details of it depend on the way in which you understand the assessment process. If you understand it in terms of probability values, what you have is basically an updating of the probability value of the hypothesis given each item of evidence and given the application of something like Bayes' theorem to each piece of evidence, updating the probability value of the hypothesis. So if I am not mistaken, in that way, you don't really have an evaluation of the whole thing at the end, because you have already updated your probability value of the hypothesis up to the last evidentiary items. So at that point, you just need to see whether the final probability value of the hypothesis, updated with any evidentiary item, meets the standard of proof or not. People who say that they have an holistic understanding of the evidence say that, well, you must evaluate all the evidence together. All the evidentiary items must be evaluated in their reciprocal relations, right? Because the set of evidentiary items connected to one another can prove what individual items cannot. That's a sort of holistic picture. And people like Susan Hack and also Michele Tarufo say, well, holistic evaluation is important, but it cannot replace the atomistic evaluation of each kind of evidence. So first of all, you have to evaluate each item of evidence in its turn for its own value. And then you can have a look at the whole thing, okay? But the details of it change according to the picture, whether there are probabilities involved or not. You mentioned one article of your law that asks to do the two things, okay? That's interesting. In Italy, we don't have that. I mean, we have just the idea of evaluation of the evidence with no specification of the steps, which is interesting. I mean, maybe there are some cases I don't remember exactly, but maybe there are also cases of that sort in some Spanish-speaking countries, if I remember correctly, in Colombia, but I'm not completely sure. There's an article about that evidence must be assessed item by item, and then the whole thing must be assessed. I'm not sure it's Colombia. Maybe I'm wrong. But again, to conclude on this point, once you accept this idea, the details of it change depending on the way in which you understand assessment to be, and depending on the fact that you use probabilities or not, use numbers or not, etc. Next, Professor Schultz. I'm with you on PERS. I mean, PERS is a great source for these matters, and in thinking about evidence. I mean, I've used a lot PERS's theory, and I basically think that inference is divided into three major kinds: abduction, induction, and deduction. What about analogy? Peirce didn't consider analogy to be an independent form of reasoning, as you know. I mean, he had the view that analogy is a sort of mixed inference that puts together different inferential steps. I mean, there's a part of analogy which is abductive, maybe there's a part of it which is inductive, and the conclusion is a sort of deduction in that you apply the generalization to the present case. So analogy is probably a sort of combined inference that combines different aspects of the basic forms of inference that are abduction, induction, and deduction. So I would say, yes, basically there are three ways in which we can perform a piece of reasoning: abduction, induction, and deduction. And analogy is rather sort of mixture between them. I don't know if this answer satisfies you, but yeah, it's a complex topic, so we would need more time to discuss it in detail. Alexander, O.J. Simpson, yeah, that's a famous case. He was acquitted in the criminal trial, and in the civil one, he had to pay compensation to the family of his wife who was murdered, as you remember. The fact that it is permitted in the U.S. depends on, yeah, the differences in the procedural system. Yeah, these are basic differences between the U.S. System and other systems like many of the continental ones in Europe. The usual story that is told about the double case against O.J. Simpson was that with the same evidence, he was correctly acquitted criminally, and the result was the opposite in the civil case, because the same evidence didn't meet the standard of proof, criminal standard of proof, but was sufficient for the purposes of civil justice. Okay, so it was he had to pay compensation. Well, that's basically correct, but if you consider the details of the two proceedings, you realize that in the civil case, there was more. There were new items of evidence against him, which made it the case that his involvement in the facts was, more supported by the evidence given these additional items. There were some pictures of him wearing some shoes. Those traces were found on the crime scene. So there was more against him. But anyway, the theoretical point is correct. The same kind of evidence can be insufficient with respect to a criminal standard like the barred one, and can be sufficient with respect to the civil standard case, in normal cases, which is the preponderance of evidence. And then the fact that that can be done depends on the system, on the rules of procedure of the system. I think, then there was Peter, but we couldn't hear his question. So
I think he renounced his idea to ask the question, and my internet is a bit acting up, so I certainly hope that you can hear me. So we started with the great and really clear presentation about philosophy of evidence. And I thank you so much, Giovanni, for it. I'm sure that we will come out of this with at least a few students interested in the topic, especially because we wrapped it up with O.J. Simpson, which is always a popular topic. So we rounded it up to be, I think, the most appealing a philosophical discussion that a philosophical discussion can be at all. In order not to, of course, I would have some additional questions, but I won't be abusing of my moderator role. And since we are usually capped at 1 hour, 1:15, I would like to thank you all for participating, asking the questions coming. And I would like to give a special thanks once again to Giovanni, who did a wonderful job, and thank him again for taking the time to give this lecture to Belgrade Legal Theory Group. See you all again soon.
Thank you all, guys. Thanks a lot for your attention and your comments. Bye-bye.
Bye, thank you.